Hi, guys. It's Kathy. I hope you're doing well. We made it to Friday. All right. The weekend for you guys. You just have to work and then the weekend. We're going to go to 3 courts today. We're going to start with Jersey, though, because, it's Jersey.
Yeah, I somehow keep ending up with hundreds of emails in my junk folder and I have to keep checking it. I don't really know what they did to our emails.
I've got an email dealing with a McNally.
Again, I'm going to fast forward it just 1 minute because
Okay.
there's
that was another
playing with emails.
our Katrina looks like
30 more seconds.
it was just a
Evaluation.
Apparently he did, I think, and he's okay.
Well, nobody sent it to me, so they're in the process of forwarding it to me.
Let me see if I
can
got
look
it.
at There we go.
I don't know, it just doesn't really say anything.
Yeah, it doesn't. Was there a report that came with it?
No, Your Honor, that's the only information that I've received regarding Mr. Delaney.
Doesn't seem to tell us much.
I can try to follow up with Lieutenant Riddle and see if maybe there's a report or something to provide.
All right, in any event, I've got a detention motion of Baroque release here. State versus Timothy Delaney. It's complaint warrant 2025-600-0810 and 2025-521-0810. Your appearances, please.
Assistant Prosecutor Kerner for the state, Your Honor.
Christopher Cohn on behalf of the defendant.
All right, is everybody ready to proceed with detention and revoke release?
Yes, Your Honor. Again, as the family court judge, Mr. Delaney informed me that the family court postponed him 1 week because they want to do it in person.
Okay.
So apparently nothing happened in family court other than that. Is that
Other than
correct,
the
Mr. Delaney?
Yes, that's correct. Thank you.
So the temporary restraining order remains in effect. That means he can't have contact with his mother or 2 Candlewood Drive in Mantua. All of
That's
that
right,
remains
Judge.
in effect. Mr. Delaney now understands how seriously we take those types of orders, because if you fail to comply with them, you end up in the county jail wearing an orange jumpsuit. But I'll hear from the state as to probable cause.
Judge, for purposes of this hearing, we'll stipulate.
All right. Probable cause being a well-grounded suspicion that an offense occurred, defendant was involved. I'll find probable cause has been established. Why should I detain him and revoke his release, Ms. Kerner?
I'm sorry, you allow me 1 moment. So Judge, the concern here is that he's going to keep violating conditions
Thank you,
of
Lena.
order, specifically that
So nice to meet you.
final restraining order that he has. Sorry, I'm just getting the right page here for violation of monitoring.
Do you
We
know
have-
what the basis is of the restraints in the first place?
So Your Honor, I believe that he wanted that, I know the mother wanted him out of her house. I believe there is a strong concern for mental health issues that are going untreated. And I'm looking for the police report because I believe this is a case where this defendant barricaded himself in his room with his dog for a few days. And if that's what I just want to confirm that.
Yeah, the police had to serve him with the TRO by sliding it under the door to his bedroom and telling him to get out. And then he came back allegedly and was walking his dog in the yard.
So that's the
Because he-
concern is that he keeps.
That's the
returning-
allegation, at least.
That's what the concern is, that he keeps returning to this address. He does appear to have some issues that aren't going addressed at the moment. He's posing a danger to others by, specifically to, I believe it's his mother, by continuing to return to her address.
I protect her. She's been hit by my
Mr.
brother.
Mr. Delaney, do not say anything. Anything you say will be used against you, okay?
I'm there to protect my mother. I have to go there.
Okay?
Quite frankly, Judge, this is one of those situations that unfortunately we don't have a mental health court set up at this time. There appear to be issues going on that are not going addressed.
The sender told me that I can go there. They accepted
Mr.
it.
Delaney, what did I just tell you?
Sorry, I promise, I promise. I'm
All
sorry.
right.
And he's continuing to return to this address. I don't know that he's understanding that he can't return to make contact with his mother. He now has these pending charges for contempt and obstruction from different days for the contempt violations. I don't think any court orders are going to do anything to stop him. If there was a facility available, that would be a different story, a facility that would help him address his mental health issues and inpatient basis, but I don't believe we have that at this time. So our only option to protect this individual and to ensure compliance with court orders is to request detention at this time.
I understand, but Mr. Cohn is going to point out that Mr. Delaney has no record, that he, to this point, has led a pretty creditable life. My recollection is that did you graduate from Villanova?
Yes. Thank you.
That he, having lived in the same environs where Mr. Delaney grew up, I'm familiar with who he is. I'm familiar with his history, and I'm saddened to see him standing before me today. Nevertheless, Mr. Cohn is going to point out that he's got no record and that there was no violence associated with his allegations of contempt. And so therefore, the defendant, I am going to find, is amenable to pretrial release. But Mr. Delaney, you got to
Thank
find another place to live.
Absolutely. I'll go to my grandmother's.
Go crash at a friend's house, right?
Thank you.
Go. My recollection is your parents are divorced. Go live with your dad
Yes.
if you
That's
need
my
a place to crash.
Judge, you seem to be his friend. You want him to move in with you?
Right?
All right. Gotcha.
I mean, I know who you are. I'm sorry that you're here. I think one of your younger brothers played baseball with one of my sons. So I'm sad to see you here, but you can't go back to your mother's house, period, full stop.
Understood.
Right?
Thank you. I
So
won't.
where are you going to go if I let you out?
Either Clayton to my grandmother's house,
What's your
Uh,
grandmother's
Washington.
address?
96 Novak Drive, Clayton. Or I can go to 98 Massey Drive in Washington Township. It might be Sewell. It's 08080. If you're okay with it, my brother has an address in Washington, DC, or in Ohio. I'll come back. I'll wear an ankle monitor, whatever you need me to do.
Yeah, I'm not even doing that. I just need to know an address where we can send you mail. So you're going to go stay with your grandma? You're going to go stay with your
Yes,
brother?
for mail, please. Yeah.
right,
Actually,
so
for
90
the mail, it'd be 98 Massey Drive, please. Just for the mail. I'll be in Clayton, though. I can get to Washington Township pretty easily. The bus gets right there.
98 Massey Drive. Is that
Yes.
Sewell?
Sewell or Washington Township, the zip code is 08080.
If it's 08088,
088,
I believe that's Sewell.
That's a Sewell post office, but it may physically be within Washington Township because Washington Township encompasses portions of Sewell
Hi, Bill.
and portions of Turnersville and a little bit of Blackwood.
That's true.
As far as postal designations are concerned. Again, I live here. I know who Mr. Delaney is. I'm saddened to see him here before me. So you can't go back to 2 Candlewood Drive. I'm going to release you on what's called level 1 monitoring. That means you're going to have to contact pretrial services 1 time per month until your charges are resolved.
Okay.
Right? You're to have no contact with your mother, whose initials are JD. You're to have no contact with her address, 2 Candlewood Drive in Mantua.
Gotcha. Thank you.
And while you're on pretrial release, and I do this condition to everybody, you're not allowed to possess any guns, and you can't use or possess any illegal drugs.
Gotcha. Thank you.
Your
Understood.
Honor,
So
I-
we're gonna use,
I'm
we're
sorry.
gonna use 98 Massey Drive.
No one else finds it suspicious that Bill is up at 4:30 in the morning? No one?
ASSEY Drive in Sewell, 8080. As his mailing address, Mr. Delaney, do you have a phone number?
85, yes, 856-217. And my email, because the phone is under my mother's name, is
Your Honor, my only request is, I know that there's been some talk of whether he had an evaluation done or did not have an evaluation done. I would just ask, so long as he's able to obtain an evaluation without cost to him or significant cost to him, that when he is released, that he go to some kind of mental health facility and have a psychiatric evaluation done. The concern is that he did have a traumatic brain injury in the past, and his mother indicated that she's concerned it has affected his well-being.
deal. I'll go to Ascenda. I already have a phone number. Someone visited me on Tuesday. I think her last name was Joyce.
And
All right, Mr. Delaney, do you have health insurance?
I'm not sure. My mother said that I have Medicaid, that she signed me up for Medicaid, and that she gave it to my dad. But then my dad said that he said he had it or he picked it up or something, but then he locked me out of the house and he left for California. So
All right, then I'm gonna ask, as a condition of your release, that you get a mental health evaluation and follow the recommendations. So if you can go over to Ascenda, that'd be fine. You're gonna end up having to sign a HIPAA release so that our pretrial services staff can make sure you follow it up. But I'm only gonna make you call them 1 time per month until your charges are resolved. This is your first time in the county jail, I think. And hopefully it'll be your last. So I got an address, I've got a phone number, I've got an email address. You're gonna be released from the county jail this afternoon. While you're on pretrial release, level 1, you have to contact pretrial services 1 time a month to check in, make sure that you know when your court dates are. You have to appear for all scheduled court proceedings. You have to notify pretrial services of any change of address or telephone number, and you can't commit any new offenses while you're on release. You're gonna have no contact with your mother, JD, or her address. Do you need to go there to get some, personal effects?
yes, a car key.
Then I will place in the order that you may go to that residence 1 time in the presence of law enforcement. So you got to make an appointment with the Mantua Township Police Department and have an officer escort you there so that you can collect your things and go. No
Okay.
guns, no illegal drugs. And you need to get a mental health evaluation and follow the recommendations.
Understood. Thank you.
Judge, as a suggestion, there is, I believe it was suggested at some point that Twin Oaks might be able to work with his insurance.
That'd be helpful.
Thank you.
All right, Mr. Delaney, you're going to be released. Stay out of trouble. And most importantly, stay away from your mom until this thing blows over.
Gotcha. Understood.
Judge,
Right?
Judge, before we
you're
leave,
28
I
years
need to
old.
address him.
Yes.
It's my understanding, Judge, everything is municipal matters, disorderly.
Yeah, they're both disorderly. So his next court proceeding, well, why does it say he's got a pre-indictment conference? I'm not showing anything other than disorderly persons
I
offenses.
think because
Judge,
it's a
yes.
DV.
No, Judge, he has 4th-degree contempt charges as well.
Really?
Your
Not showing
Honor,
up on my PSA.
The police told me to
Uh,
meet them car to get a jump,
I-
and then they arrested me instead.
I've got the older PSA. That's all right. In any event, your next court date is July 24 for a pre-indictment conference. There's also a pre-indictment conference on June 26th. That's with me. That's a great opportunity for you to resolve everything.
Thank you.
State's not going to ask to send you to state prison or even put you in the county jail. They're probably going to ask you to do a short period of probation, which, by the way, might be a way that we, meaning the system, can help you. because it looks like you need a little help.
Thank you.
All right, you're gonna be released later today. Read your paperwork carefully.
Thank you. I'll do.
Thank you,
Good
Jay.
luck to you.
Thank you. Thank you, Mr. Connor.
You're welcome, sir. Good luck.
Thank you.
Can you turn off the live stream for a minute?
Well, it was not, in fact, a minute. It was the rest of the day, but that's fine, Judge. That's fine. Let's go to, I can't remember.
Chris deciding that a
Or
misdemeanor resolution, 5 days cap jail.
It's in Colorado, 100%.
Led to Chris deciding that a misdemeanor resolution with 5 days cap jail was potentially in his best interest. But I know he was on the fence on that one, and he was going back and forth. And I know today's going to be a tough day for Chris, just to sit through this and deal with this. And there's a lot of emotion, and there's a lot going on in this case, as any domestic violence case has. But I think this one may have a little more. Considering the facts and considering the overall situation of this relationship, we're asking for no additional jail. Chris works a lot. He has housing. He has stable employment. Going to jail even for a few days could potentially throw that into question. I do believe he should have a couple days credit for time served already. So if the court is looking to do any jail, I would ask him to look at the time served already and remove that off the cap. In addition, we're asking for just light or no community service and a small fine. I know finances have been an issue for Chris throughout this situation, so a large fine by the court could cause a hardship, especially if he does have to pay for this probation. No further argument, Your Honor. Thank you.
Mr. Neifert and Mr. Cruz, you can make a statement on your own behalf for sentencing. You don't have to if you don't want to. Would you like to?
Okay, here's where the lawyer should have prepped him a tiny bit before he opened his mouth, but the lawyer did not prep him at all.
I would. Honestly, Your Honor, the night in question, my life was in danger. I did everything I could to try and get the both of us home safely. I think it ended up, I had to drop her off on the side of the road and she walked, and that was the only way it could be ended. I wasn't feared for my life. I was beaten, choked, headbutt. She grabbed the wheel, tried to take it off the road numerous times. This wasn't the first time. It happened the night before this. In between those two, she also got in a fight with her mother. You know, I was very much a victim that night. I did everything I could to get the both of us home as safely as I could. But you know, people look at a picture of bruises on a woman and they don't question much. The cop didn't care to question anything I said, didn't ask anyone that I said to talk to, anything. He just wanted to put cuffs on me and throw me in jail. I honestly feel more of a victim today, taking a charge from our judicial system for being in fear for my life and under this event. But unfortunately, my phone was lost a month after this incident happened in an accident. I didn't get it back. It was retrieved. I never got it in my possession. And when I got a new phone, the entire month of September's text messages and pictures were completely deleted out of my phone. I didn't have any chance to even take this to a trial. I had no defense. Otherwise, I definitely would have. I was definitely a victim in that situation. I've also heard since then that numerous times since I've left, her mom and her have been in many fights and had the police called to their home to the point that she's no longer around. I didn't do the things that I'm being accused of, but unfortunately, I have to do what I have to do to protect myself. And like Mr. Neifert said, I'd rather take a misdemeanor than trying to fight this in a jury court without the proper evidence to prove my innocence and end up with a felony. I don't really want to, but it's the better of two choices. And for the next 2 years, I'm going to be a victim to this still under probation.
Okay, so the lawyer didn't prep him at all. which makes me wonder if the lawyer didn't listen to him to begin with, where he's saying he's the victim. I don't know if he's the victim. I know that she was beat up. She had, swollen eyes and bruises all over her face. That we know because there's pictures. I know that he left her in the middle of nowhere and drove off. I know that because he just said that. So who knows if he's the victim or she's the victim, but I'll tell you who really doesn't know, and that's his attorney, because I don't think his attorney even bothered. I mean, if he was getting choked and beat up, first off, he would have marks. And that's a defense. That's a solid defense in court. I mean, if I got hit and I kicked that person out of my car and left them in the middle of nowhere, there's nothing illegal about that. Nothing. But I don't know. Maybe he didn't listen to his lawyer at all. That's possible. His lawyer could have said, yeah, I hate blaming lawyers. I do. I don't know about this one, though. I just don't. Because his lawyer had to have told him, listen, do not play the victim in front of this judge. All right. Let's just keep going to see how the judge reacts to he is the victim speech.
Pain and everything. It hurts a lot, but that's what it is. So that's really all I have to say. I really was a victim that night, but I can't do much about it, so I'll accept the best I can. Thank you, Your Honor.
Thank you, Mr. Cruz. So I'm going to make the court sentencing order will be as follows. I'm going to make a finding that the people have VRA compliance for purpose of sentencing. I'll also make a finding that this crime was committed as an act of domestic violence. 801.
Thank you, Thank you.
Per the parties, per review of the file, rather. With regards to the fine, I'll begin there. I don't typically impose fairly high fines. In this case, I have discretion up to $1,000. And I don't think fines are necessarily a deterrent in these situations. And I'm going to get to that deterrent later on. But I'm not hearing a whole lot of taking accountability.
So what she basically said is, I hardly ever give anybody fines in cases like this because I don't believe fines work.
From Mr. Cruz, I think a fine is appropriate as a result. I am going to be imposing a $500 fine, and I will order
But for you give me $500.
that Mr. Cruz pay costs per statute. I'm also sentencing Mr. Cruz to 24 months of supervised probation. That'll be with the standard terms, and performance of all other terms is also a condition of your probation. I will reserve my authority under 18.1.3202 subsection 1 to impose up to 60 days of jail as a condition of probation. I'm not going to be imposing any jail today, however, and I'll get to that. I'm ordering you to complete a domestic violence evaluation and successfully complete any recommended treatment. You're not to use, consume, or possess alcohol, controlled substances without a valid prescription. With regards to the jail, I'm noting that the court has discretion up to 5 days of jail, but you have credit for 5 days already. As a result of the lack of accountability that you essentially just described, Mr. Cruz, I would impose the maximum jail in this case. However, you already have credit for 5 days served, so you're not going to be serving any additional jail. So that'll be, I'll order that you complete 5 days of jail, but you get credit for 5 days. With regards to the community service, as a result of the underlying facts, the facts indicate that there were a number of bruises on Ms. Hood, and additionally, again, there seems to be a lack of accountability in this case. I am going to be ordering that you complete 48 hours of community service, and that will need to be completed within 6 months. $120 fee will go with that for insurance purposes. And Ms. Haas, is there any restitution in this case?
Give me 1 second, Judge, and I will be able to tell you that.
And Your Honor, on the plea paperwork, it indicates there is no restitution.
you.
And that is correct, Judge.
All right, I'll make a finding of no restitution. And finally, you're not to use or possess or purchase any firearms, weapons, or ammunition during the term of your sentence. There was a PR bond that was posted by Mr. Cruz. That bond is discharged. As a result of the plea, I'll go ahead and dismiss your rate case 25M9. That's Mr. Cruz's other your rate case. That's per the plea, so there's no order to seal that will issue in that case as a result of that dismissal being part of the plea agreement. And then Ms. Haas, you'll need to file a motion to dismiss in San Miguel case 25M25.
Will do.
Okay. Okay, is there anything further, Mr. Knifer?
I don't believe so, Your Honor.
Ms. Haas, anything further?
Nothing further, Judge. Thank you.
All right, Mr. Cruz, you'll need to go directly to probation to get that domestic violence evaluation set up, okay?
Yes, Your Honor.
All right, we'll go ahead and move on to our next case. I can see Mr. Ship is logged in. And thank you, Mr. Ship, for your patience this morning. I'll call Deathridge's case 25T55.
Good morning, Your Honor.
Good morning, sir. And do we have Devin Deathridge in the courtroom?
Morning, Judge.
Okay, and he appears in person in the courtroom, Mr. Deathridge. And we've got Mr. Ship again appearing on Mr. Deathridge's behalf. We're set for an appearance on bond. Mr. Ship, do you waive further advisement in this case?
Yes, I do, Your Honor.
Okay, and I saw a number of filings with regards to the medical marijuana card, the ADHD subscription, and the substance testing report. I'll just turn to Ms. Haas. Is this a first, second, or third offense?
I was unable to hear Ms. Hawes. This is an alleged first that I can see, Your Honor.
Okay, Ms. Haas, can you confirm that? You're on mute, by the way.
Sorry about that, Your Honor.
That's okay.
This is a first offense.
Okay, and Mr. Ship, are you requesting to remove the DUI testing then?
Yes, Your Honor. This is an alleged marijuana case. No alcohol was mentioned in it. And now that he has a medical marijuana card, I don't think it's necessary that we continue it.
Well, it's sort of a first offense. Sorta.
That was my thought on the filing. So what I'll do is I'll go ahead and remove the requirement. As it is a first offense, DUI testing is not a requirement for a first offense unless the court makes specific findings. I'm going to go ahead and remove that for now based on the filings. So there will be no DUI testing as a condition of bond. And Mr. Ship, presumably you need to set over. I'll ask first, do you have initial discovery in this case?
It looks like I do have body-worn camera and discovery. I've not had an opportunity to review it yet. So if we could push this out maybe 1 month, I think that would be sufficient.
Sure.
Judge,
Go ahead, Ms. Haas.
I'm sorry, Judge. I just wanted to correct the record. I just double checked my notes. Mr. Deathridge did have a DUI in 2015. He received a deferred judgment with 24 months of supervision. We are still working on obtaining that certified conviction, but it does look like this is a second, so I apologize.
Okay. In that case, Ms. Haas, is there any objection to removing the condition of bond for DUI testing?
No, Judge, I have no objections to that. That's fine.
Okay. All right. So, Mr. Ship, are you available on June 26th at 10 a.m.?
Yes, Your Honor.
Okay, we'll go ahead and continue this case to June 26th at 10 a.m.
And Your Honor, Mr. Deathridge lives in Denver, Colorado, so it's quite a long drive for him to come to court. May we request this to be virtual for the remaining of the hearings that are not containing some substantive issues?
It's actually going to be my next question is where does Mr. Deathridge live? So Mr. Deathridge, you can go ahead and appear via WebEx for that hearing. And essentially what you'll need to do is just for sentencing, you'll need to be here if there is a plea. Or if there's obviously a jury trial, you'll need to be here in person. So at any rate, anything further in this case, Mr. Ship?
Nothing further, Your Honor.
All right, thank you both, and we'll see you on June 26th.
Thank you.
Thank you, Judge.
Thank you. And I believe we've got Mr. Matsuda in the courtroom, who had a ticket. And sir, provide me your full name.
Yes, my name is Caden Matsuda Whaling.
Okay, Mr. Matsuda, and your parents are with you, is that correct?
Yes, they are.
Okay, this was a situation where there was a ticket that was, it was an infraction ticket that has not been received by the court. The sheriff's office has not provided it to us. So essentially what we have to do in these cases is dismiss it. So you're free to go, sir. There's nothing you need to do.
Thank you, Your Honor.
Have a good day.
Yeah, you too.
All right, and the court will be in recess until 10 a.m. And thank you, Ms. House. We'll see you then.
I thought there was one more that I wanted to. Oh, okay. We'll do this.
Sympathetic people's request, and I'd be inclined to have a hearing on that right now if we were able. I'm also happy.
I don't know, but I think he murdered their daughter, his daughter and her daughter, but I'm not 100% sure because they don't really say.
To rule on it. But Mr. I don't want to inquire of him individually. Now that we have counsel, we're just in a little limbo here.
Yes, and unfortunately, I mean, I would agree, but I don't believe that the court would require him because I know to make argument on his behalf.
All right. So
I think, Your Honor, that Mr. Mills needs to have an opportunity to respond to the people's motion. He has not even seen it, I suspect.
correct.
So I think it's unreasonable for the people to be granted their request today when he's in transit as far as he now has legal counsel on paper, but obviously that individual hasn't had a chance to respond or contest the people's motion.
And mindful of the people's urgency on this, I do think that it does need to be addressed quickly. We're going to move expeditiously to get you a counsel appointed, and we're going to give a very short time frame for a response. I'm happy to set it in for a very quick turnaround, and if necessary, if I have to rule on it, I can rule after I've had I'm going to need a response very soon, and then I can address bond at the next hearing if necessary. So if I have to rule on it in the meantime, I would still give your counsel a chance to chime in, and we would set for a bond hearing. Ms. Mead.
Your Honor, so two things are happening in this hearing. The first thing is his attorney has a conflict. So the district attorney's office has to withdraw. So they're withdrawing, which has created a continuance of whatever they were doing because he has no lawyer now. And they have to appoint him a different lawyer, which they did, but just like today. So he hasn't met with them or anything. Second thing, they want the prosecutor and the family and the victim. This is a victim. I really do still think there's a murder victim as well, their daughter. They want his bond raised real high. And they brought this emergency motion to raise his bond because they think he's going to get out of jail.
It's an emergency motion. It's incredibly time sensitive. Mr. Ridgely was not withdrawn officially until today. He's had this motion since the 23rd and had a chance to confer with his client. And again, the nature of this motion isn't one where he'd be necessarily interfering with another counsel that might be. He was counsel at the time this motion was filed. Just today, he was relieved. The people are asking the court to rule on this motion It's incredibly time sensitive. And the new defense certainly can file a motion to modify bond on their own as well to reduce it if they feel that they have information. But again, the victims are happy to weigh in. We have the information from the non-party who provided this concerning information. The defendant at any moment might be released on bond, and we are very concerned as indicated in the motion. We'd ask the court to rule on it today and allow defense to file an additional motion, which the people would respond to modify bond downward.
Mr. Ridgely, obviously, I'm going to grant your motion to withdraw today. My question for you is, do you feel comfortable chiming in?
I do not, Your Honor.
I understand that situation. All right. And it sounds to me like the people have indicated the victims want to be heard on this matter. Is that correct?
Yes.
All right. So we're here.
That was impressive, though. We usually don't hear a lawyer pass up a chance to chime in, and he did. He just passed it up. Now he's not allowed to speak, but he does anyway. Don't worry.
The victims are familiar with the contents of the request.
Yes, I do believe they're aware of it.
All right. Who is here to speak on that matter? I see a hand going up. Two hands. All right, we'll start with the one titled April. Is it Bahunik?
It's Bahanik, Your Honor.
Bahanik, thank you.
So I'm April Bahanik. This is Guy Crosby. We are Shaylin's parents. We will again assert or recommend or request that the court grant a higher bond for this individual. We believe he is a danger to the community. He will reoffend, I'm certain of that. And it's very hard to sit and go through these hearings where there's not much progress, and we are still without our daughter.
Anybody else who's here?
Well, yes, Your Honor, my name is Guy Crosby, Crosby. I'm Shaylin's father. I do believe that this individual is a flight risk. And if I would ask the court if he has any passports that he's surrendering them to the court. I want him to face justice. Get his day in court also. I don't want to see him turn and run. Thank you for letting me speak.
Thank you, sir. Anybody else who's here who wants to be heard? Okay, I see Ms. Wadman.
Yes, I'm Martha Wadman. I am a victim in this case. As April and Guy said, I would request that the bond is raised. Again, I think this individual is a flight risk, and he's an extreme danger to the community, and he has proven that in his actions that have caused this case today. And just this information that we have heard from the people has been extremely distressing to me and my family, and yeah, I want his bond raised. Thank you.
Okay. Okay, anybody else?
Those are the only victims online. Ms. West is not a non-party, but did provide the information the people included in our motion.
Thank you very much. I appreciate that. All right. So, Mr. Mills, we're going to go ahead and get appointment of counsel through ADC. The public defender has put their conflict on the record, so we will reach out and get that known to you soon. I'm going to set it for a quick turnaround, and I'm going to rule on this motion. Let me get you a date first. June 9th at 9, so it's a quick turnaround. We're doing a quick turnaround because in an abundance of caution, I'm going to grant the people's request, but we will address it at that 9th hearing. And we will make sure we set a date for your counsel to respond. It gives your counsel a chance to respond in a meaningful way. And then we will hear from you on the 9th through counsel. arguments about why we can address it, if there's any reason to change it. For right now, I'm going to grant the people's request so that we can get back here and address it with council. And I'll listen to what you're.
Buddy, hi. So you were unsubscribed. Did you get to subscribe again? I'm just reminding you in case you didn't. Budgie was unsubscribed from my channel for no reason.
Council has to say.
She thought I
would
stopped
just
screaming.
point out, Your
Screaming.
Honor, there was no testimony here about any changed circumstances other than the people's suggestion that it was time sensitive. The criteria that established, that the court used to establish the bond at $100,000 hasn't changed based upon what I heard in court this morning from these witnesses. Yeah, they may be sincere, but nothing's different. So I don't see that there's any reason objectively to increase the bond for the people's request.
Yeah, and if it turns out that that's the case, then it'll be put right back. And I'll address that at that time. That's why I tried to turn it around for a quick turnaround so that we can hear from him as soon as possible with counsel.
So I'm going to be
mindful of
out of
this.
this case at this point,
Yes,
then, Your Honor.
I will grant your withdrawal motion today.
One other thing, Your Honor, I have a letter from an insurance company to Mr. Mills. Is there any objection to my physically giving it to him here this morning?
That's,
As long as we're here, otherwise.
yeah, I haven't signed that order yet. I'm going to sign it today. You've got information for him. Well, even if he was your former client, you can give him stuff that's for him. I mean, I don't see why you can't.
It's nothing criminal, actually. It's just a matter of logistics.
Well, I try not to get involved in your logistics.
All right, thank you, Your Honor.
All right. Anything else?
Why would you ask the judge that? Just hand him the piece.
We'll see you on the 9th,
and
and I want to make sure that you can hear from your counsel.
Today or tomorrow, I mailed it last week. It shows the motion that they're filing that the court's ruled on here. Okay. Okay. Good luck, Shane. Thank you, Your Honor.
Thank you. Okay. Thank you all.
Thank you.
What do you think? You think that he murdered them? I mean, do you think he's alleged to murder them? It looked like. I don't know. I think they said murder. They did. All right. I think these are just this guy. Yeah.
What are we looking at in July?
The only date we have, the 21st.
Is that week a possibility? Is it just the 21st?
Just the 21st.
Okay. We'll take
Unless some trials go away.
because I think I had something on the 24th, but
The 21st is the day.
Okay.
Okay. So you're saying
we will take the 21st?
10:30?
Yes.
It's my deep hope that something opens up before that, but until it happens, we're just going to pile up on the 21st.
Understood.
It's just not fair that you can speak with an accent and you can type with an accent.
All right.
It's
All
just
right.
not fair.
I see Mr. Wagner online. Can we call Mr. Wagner's cases?
All right. So 24 CR 1456, 5 CR 74, People versus Matthew Wagner. Mr. Wagner,
Yeah,
you're there and now you're gone. Can you hear me?
Yeah, I'll keep continuing my video.
All right, there we go. I can see you now. Mr. Morris.
Yeah, we've got an offer from the prosecution. I'd like some time to finish reviewing that with Mr. Wagner and let him have some time to make a decision. I think we can probably make some decisions by the time we come back, especially if that is in July. So this would be another case I'd ask for July 21st, please.
Your Honor, there's an explicit note that at the last hearing, the defendant was ordered to be here in person, so I'm curious why he's not.
I am not there in person because I don't have transportation and I just got out of the hospital. I have a really bad infected finger and Yep.
Are you in Teller County?
Yes, yes, sir. I am at the residence of where I have given you guys. I have not gone anywhere other than the Woodland Hospital once. I have no transportation. And I'm still helping my mom
Mr.
with her health
I
care.
I had noted
her health.
before that I had granted him this ability when he was in Teller County. What I would say is I did intend for you to get here this time. I will allow you to do it this once. We can address that before we set our next date so that we can be clear on what the expectations are. And so I'll address that in a moment. But Mr. Morris, I'm sorry, I got sidetracked there. You had requested a
Yeah,
certain amount
I
of
think
time.
if we can get Mr. Wagner here in person for July 21st, that way we can enter.
I hope the jail order is the same. You're going to jail for 17 years. Unless you don't have a ride to the jail, then you're good. Just say at your mom's house.
Not guilty pleas and set the newer cases for trial, or we will have a resolution at that time. So the 21st of July, please.
So what that means, Mr. Wagner, is that one way or the other, what I said earlier doesn't apply anymore. It's now just, you got to be here in person because it's either going to be an arraignment or it's going to be a disposition.
I have no way of getting down there. Like
Hold on a minute.
That's setting.
I'm setting it out.
failure.
I'm setting it out to July 21st. That gives you almost 2 months to figure that out.
I don't know how I'm supposed to
I'll let
figure that
you-
out. I have no way of making money.
I will let you
No,
work
I
that out,
really-
sir. Stop. We'll let you work that out with your attorney. You have almost 2 months to figure it out. 10 o'clock.
Okay, and if I do not figure it out, then may I appear virtual?
No, you go right to jail.
If that is the last ditch effort, I don't know what else to do.
If we're going to do one of the two things we're setting for, you're going to have to be here in person. I always will entertain motions, but I'm going to let you work that out with your counsel. As we're sitting here now, we're either setting for an arraignment or disposition, and you have 2 months to figure it out.
Okay, can I go into a breakout session with my attorney real quick?
I can't do that today with you, Mr. Wagner. I'm happy to, I sent you an email yesterday. If you wouldn't mind responding to that, we'll find a time to talk outside of court.
He can't respond to your email because he doesn't have a car. God, come on, guys. Court, get with it.
Okay, can you just call me after court, please? Because I have a hard time reading.
It's not going to be today, but if you respond to that email, I'll set up a time next week with you.
Okay, thank you.
Thanks. All right. Okay, we're set for arraignments or disposition on the 21st.
Yes.
All right, thank you.
That guy is going to disconnect from video and going to go yell at his mother for something. You watch. I mean, we can't watch. I would like to watch, but he probably disconnected and then said, "Mom, why did you put mayonnaise on this ham sandwich? You know I like mustard with my ham sandwiches. Except for yesterday when I told you to put mayonnaise on. But other than that, it's always mustard." We should go check on his mom. His mom's not okay.
Thank you. Thank you.
And Mr. Morris.
Mr. Bondrescu's here in custody. We're ready for that one.
25 CR 5105, People versus Maximilian Bondrescu, who appears in custody. Mr. Morris, we're here for a possible disposition. This is our first disposition date. I imagine you have a lot of information.
All they do with that guy is set a date on a calendar. You're not missing nothing. Nothing happens. Let's go to Arapahoe, Boulder, Denver. So this guy,
She's staying home.
Hold on. This judge is really, really growing on me a lot. He's really harsh often. So we're just going to watch him for a little bit. But if you look, that's Denver. There's Adams County waiting. Boulder's waiting for him. Douglas County's waiting for him. I don't know why. I don't understand why, but he gets all these different counties. I'm just gonna fast forward it just for a second. I want to know if we get the Boulder jail. He's in Boulder. He's right here. That's him. I mean, it might not be him, but it sure looks like him, doesn't it? So I want to see if I only watched like the first 30 because that's all I was going to play. But I want to see if he goes to Boulder jail. Yeah, he does. Because look, they're clearing out. Right around here is where he does Boulder jail. There's Arapahoe. All right, we're just going to press play.
She's staying home. She doesn't have access to electronics.
Thank
There
you,
have been
Donald.
multiple times that she contacted the victim, both in person, manipulating the victim to have contact with her, breaking into the victim's home, menacing the victim. She has strangled the victim again. There have been multiple instances of strangulation. I think she presents as someone who has demonstrated that she is not going to follow the court's orders to have no contact with the victim in this case. The stalking behavior by itself has caused serious emotional distress to Miss Maxwell. She's gone as far as, leaving her home, going and staying at hotels and other safe places. Miss Maxwell or Miss Sanchez has been able to track her down and continue the repeated pattern of threatening to kill her, strangling her, and trying to manipulate her. She's used other people's devices, family members, electronics, friends to contact her. And at this point, I'm asking the court to set bond the amount of $75,000 secured with no cash option, pretrial supervision, no weapons as bond conditions.
I'm trying to call the judge in the middle of the
The
street.
court. I'm not sure whose phone is ringing. Is that somebody's phone out in the gallery or somewhere else?
They wouldn't have hands. That was the Avon lady too. Now you missed the sale.
Unmuted. So I don't know where it's coming from.
Does anybody know of any Avon ladies? I'm sure there's still Avon ladies. I'm positive there's still Avon ladies, right? Right? Yeah, that's it. That was who was on the phone.
All right. Regarding the bond 25 CR 678 has been revoked. The court will reset bond in the amount of $50,000 cash or surety. Original terms.
Now I want to be an Avon lady, not Mary Kay, although that silk hands, satin hands is just one of the greatest things that the planet Earth has is Mary Kay's satin hands. But now I want to be an Avon lady and go knock on the doors around my neighborhood and sell them perfumes and lipstick.
In conditions, and I'll add a term.
Not
or two.
Amway.
No contact with the alleged victim.
No
No any way, electronic, in person, direct, indirect, through other parties, through other parties, electronic.
Listen, we can do Amway right here. Okay. It has to be, Monica. I'm not going to live in a world that doesn't have Avon. All right, guys, we're going to create our own Amway here. All right. I found 2 people to watch Court Vibes. Now, each of you go and find 2 people to watch Court Vibes and get them to go find 2 people to watch Court Vibes. Keep going.
Zero contact. Pretrial supervision via CJS. Report to CJS within 24 hours of bonding out. Possess no weapons. Or correction, report to probation within 24 hours of bonding out. And pretrial supervision via probation. I'm going to set that case, since you're going into custody today, and if you remain in custody, that status conference will convert to a preliminary hearing to ensure your right to challenge probable cause. In that case, it will remain June 12 at 1:30. I'll have the DA note.
Yeah,
This case is currently set for status conference. It's now a preliminary hearing unless the defendant bonds out. So you should plan accordingly. Ms. Sanchez, the deputies are going to come take you into custody today. You're able to post that bond if you're able.
Please, deputies, don't strangle her. Please. Geez, I would hate for her to get strangled a couple times while she's in prison.
And then I'll see you June 12, 1:30. Thank you, ma'am. Yes, I was on my.
All right, now I'm gonna look up Avon.
Ms.
See if I can get
Fernando
Avon
Lopez
ladies.
Ramirez, Lopez Ramirez.
Fernando Lopez Ramirez. Good afternoon, Your Honor. Rosemary McCoy, 7043 Spanish interpreter.
Thank you. I was just checking to see if he's here. He is still not here. If you're okay, I'd like to release you and we'll call you. Oh. For what case? Okay. Oh, not coded. Okay, so I do need to keep you, Ms. McCoy, for one other case. We'll do a breakout with Miss Land PD.
Of course, no problem.
Thank you. I don't see Mr. Ernst online. Did you see him logged in anywhere? Okay. Is there anybody else who's here in the gallery, who's here on their own case? One person? Sir, would you come up?
Sorry, guys. I can't stream anymore. I'm gonna be an Avon lady. I'm gonna sell everything I have to buy beauty products and become an Avon lady.
To the microphone. Tell me your.
Robert Ernst.
Oh, Mr. Ernst, I thought you were in the hospital. How are you doing?
I just made it.
I was just asking about you. I was concerned you were still in the hospital. So they released you and you got over here.
Yes. for the
Okay,
court.
thank you for doing that. I very much appreciate the effort for you to get over here. So thank you for doing that, sir. 25 CR 713. I was looking for you online, and I didn't see you. You're here for the filing of charges as well. In your case, this is just a summons, a felony summons. So you're here on a summons. Mr. Ernst, are you able to read that document, that complaint on your own?
Yes, sir.
Based on that complaint, I'm going to set you for what's called a preliminary hearing. That'll be June 11 at 9 a.m. in Division 7 at the Main Justice Center on 6th and Canyon.
Yes, sir.
Not here.
I
Questions about anything going on?
won't be released from the hospital until June 4th.
You going back in?
Yeah, I left today to come to court.
Okay. So if you're in the hospital on June 11, just let us know.
Okay.
Okay.
And you set the court date again?
It's written down right there for you. June 11, 9 o'clock.
Thank you, sir.
All right. Thanks, Mr. Ernst. Thanks for making the
Have a
the date here today.
Have a good day.
You too. I think I didn't see any other hands. Anybody else here on their own case? None. Okay. Let me check one. Is Dinesh Katka here?
Yes, Judge.
Mr. Katka? Let me just check and make sure we have our interpreters, our Nepali interpreter here.
Yes, Your Honor.
Thank you for joining us.
Nepali interpreter.
The case, if you don't mind going out of order, Ms. Bukowski. Okay. The case is 22T 937.
22T937 दिनेशजी तपाईको यो आजको केस नम्बर
Is
Yes.
good afternoon to you, sir.
आज शुभ दिन तपाईको लागि
Is a post-judgment matter with a complaint alleging you violated your probation
तपाईले त्यो प्रोबेसन मा हुँदाखेरि चाहिँ त्यो पुरा नगर्नु भएको भएर त्यसको लागि यहाँ थुनामा परि
regarding bond, Ms. Volkowski.
तपाईले चाहिँ जुन जमानतमा छुट्ने भनेको अब कुरा गर्दैछु
Yes, Judge. Mr. Kortka supports both of his parents and his children through his job.
तपाईले चाहिँ आफ्नो परिवारलाई आफ्नो आम्दानीबाट पाल्नुहुन्छ त्यसैले आज छुट्नको लागि कुरा गर्दैछु
Although he is not currently employed, he does have leads for jobs as a cook in different restaurants.
अनि तपाईले अब हालमा तपाईको काम नभए तापनि तपाईले खाना पकाउने काम चाहिँ रेस्टुरेन्टहरुमा गर्नुहुन्छ त्यसैले यहाँबाट छुट्ने बित्तिकै त्यो गर्नुहुनेछ
And due to his low income and inability to pay bond, any amount of bond would be sufficient to a no bond hold. or
तपाईको
equivalent.
चाहिँ पैसा नभएको भएर अब थोरैमा थोरै जति तिरेर भए पनि छुट्यो भने चाहिँ बाहिर गएर काम गर्ने कुरा गरे।
And so we are asking for a personal recognizance bond on this case, and he already does have the public defender on this case.
तपाईको चाहिँ अब जति सकेसम्म आफ्नै जमातमा छुट्ने भनेर कुरा गरिरहेको छ यहाँ।
And बाहिर गएर काम गरेर आफ्नो प्रोफेसन रिइनरोल पनि गर्छु।
I'll make sure that I go outside and work and make some money.
The public defender has already entered out of custody.
Yes.
तपाईलाई चाहिँ त्यहाँ तपाईको तर्फबाट लड्ने मान्छेले कुरा गरिरहेको छ।
DA Bond.
Thank you, Your Honor. Joshua Diller on behalf of the people. So I'll keep going. I'm gonna, Your Honor, I think bond was appropriately set by Judge Brodsky at the failure to appear.
तपाई त्यो पहिले बोलाउँदाखेरि उपस्थित नभएर पहिले नै त्यहाँ कति जमानत राख्ने चाहिँ भनेको छ।
Thank you. Bond is set in an amount of $5,000 cash or surety with conditions. Report to probation within 24 hours and comply with probation.
तपाईले 5,000 को धरौटीमा या त नगद तिर्ने या त कसैले जमानत बसिदिने त्यो गर्यो भने तपाई बाहिर गएर चाहिँ त्यो प्रोबेसनको 24 घण्टा भित्र चाहिँ हाजिर हुनुपर्छ।
Ms. Polkowski, did you discuss your client's right to have his hearing within 14 days?
Yes, Judge.
I'm going to have, it's okay. For our interpreter, I'm just going to mute the defendant because he's speaking over people. I'll unmute you in a minute.
Okay.
Ms. Polkowski, would your client like to have an evidentiary hearing within 14 days or set this out a little later?
He is going to want it within 14 days, Judge. And I do know that there is a Nepali interpreter, I believe on May 30th at 2 p.m. in Division 8, already pre-scheduled with Clerk Mr. Lammers.
तपाईको लागि चाहिँ यो 30 तारिख पनि यो दो भाषीले कुरा गरेर त्यो जमानतको छुट्ने कुरामा गर्नेछ।
That is 2 days from now. It is possible, matter of fact, likely the DA might not be able to secure a witness within 48 hours. DA, can you give that a try?
I don't think we can do that, Your Honor. I can try, but having a probation officer subpoena within 40 hours is kind of a stretch, I think.
Okay, I'm going to set it May 30, 2 p.m., Division 8, with an asterisk. DA may request continuance for good cause.
तपाईलाई चाहिँ अब 30 तारिख फेरि यहाँ हाजिर हुनुपर्ने छ र तपाईलाई चाहिँ जुन प्रोबेसनको कुरा गर्नलाई जमानत जति छ त्यो चाहिँ उहाँहरुले तोकिसकेको छ त्यही अनुसार चाहिँ तपाईलाई 30 तारिख आएपछि 2 बजे यो फेरि यहाँ सुनवाई हुनेछ।
Anything else on the case?
No, Judge.
All right. I'm going to unmute you, Mr. Katka. If there was something you wanted to say, I couldn't hear you, you can say it now.
तपाई दिनेशी अब चाहिँ तपाईले बोल्न सक्नुहुनेछ के भन्नु छ?
I have nothing to say.
No, Your Honor.
All right, we'll see you in 2 days.
2 दिनपछि तपाईलाई यही हाजिर हुनुपर्ने छ है।
Wow, Clarice, thank you so much. I really appreciate that. Thank you.
See, Douglas County, is that you, Mr. Thompson?
Yes, Your Honor.
Okay, let's take, can I take your, I think I lost your public defender. She's in a breakout, so I'm gonna have to pause on your case for just a minute.
Yes, Your Honor.
Mr. Louth, you ready on your case?
Yes, Judge, I am. I got a couple.
A few, can we start with Gamma Acosta?
Yes, please.
25 CR 740. Mr. Acosta, right here?
Yes, Your Honor.
You're good there, sir. Good afternoon, sir. Case 25 CR 740 comes on for filing charges. Mr. Lau.
I'd give you $1 million.
Yes, Steve Roth on behalf of Mr. Acosta, and we would be asking, well, we would acknowledge receipt of this complaint, waive any reading thereof,
Or at least it
further
doesn't
advisement, and
mean.
ask for a
I'd give you
preliminary
it doesn't
hearing.
mean.
Can you do June 11 morning? It's an off docket PH. Off our normal cycle.
Actually, I'm titled that week.
16th?
The 16th of June?
Correct.
I can do that.
DA.
Your Honor, I know that this is Miss Hollander's case and she's going to be in a lengthy murder trial from the 9th to the 20th. So I don't know if she'll be able to make that date work. However, she may be able to find coverage.
We're fine waiving the 35 days.
Let's set it on the 16th and let Miss Hollander figure that out. You and Miss Hollander can chat, and if you want to push it out, I'm happy to do that. Let's set June 16th, like the morning or the afternoon better? Morning?
Afternoon, please.
Okay. June 16, 1:30 p.m. Division 7.
And then if I could address Bond briefly as well.
DA, you prepared to address Bond in Mr. Acosta's case?
Yes, Your Honor, we are.
Go ahead, Mr. Lau.
Judge, I do note that he does have that attempted second degree assault charge there with the 4th DUI. But I can tell the court that his pending DUI.
Listen, I know he has 4 DUIs, but he doesn't really have any real history, Judge. I mean, his first 2 DUIs were way too long ago for even to consider. And the other DUI in 2024, I don't think that should count. So, yes, this is his 4th DUI, but really, this is his first time he's ever been in the criminal justice system, Judge.
A case where he had already accepted responsibility, pled guilty, and it was set for sentencing. He did have a bond condition of no alcohol, but he was not on monitored sobriety. And he tells me that that's obviously a downfall for him. And he took responsibility for that DUI. He's more than happy to comply with monitored sobriety. If the bond is reduced, he can't make that bond of $15,000. I would ask the court to consider reducing it to a $5,000 surety bond with a $500 cash option. I can tell the court that other than the DUIs, he's been a lifelong resident of Boulder County and has had no other problems other than the 2 DUIs about 20 years ago, and then a recent DUI in 24, and now this DUI.
Got it. Thank you. And let me hear from the DA.
Your Honor, the people would be objecting to any decrease in bond. It's extremely concerning to the people that the defendant is picking up new DUIs while awaiting sentencing on a DUI. Also, his conduct with police was concerning, as was the amount he drank. Of course, he refused chemical testing, so we can't know exactly how much he had to consume, but officers did find 6 empty vodka shooters in the car. So he at least had that much. And for those reasons, we do object to decrease in bond.
Thank you. The request to modify bond is denied at this time. Bond remains set. We'll see you at the preliminary hearing June 16, 1:30. See you then, sir. Mr. Louth, I preset that June 11th for all your cases. So remind me that I have to change them to June 16th.
Okay, thank you.
Mr. Nye here.
Judge, he's in custody as well. And
25 CR 726, Mr. Nye. Good afternoon, sir.
Good afternoon, Your Honor.
Case comes on for a filing, Mr. Louth.
And Judge, we would acknowledge receipt of this complaint as well and waive any reading of it or further advisement. Would ask for a preliminary hearing, and that date of the 16th would work well.
June 16, 1:30 p.m. Division 7 preliminary hearing.
And then if I could, I see that a bond argument was reserved for today. If I
Jill's going to get a new hole in their drywall soon.
may make
Yes,
a-
yeah.
Judge, Mr. Nye has no other criminal history other than these 3 prior DUIs, which I note that 2 of those DUIs are 30 and 35 years of age, and one of them is approximately 15 years of age. But other than those DUIs, he has no criminal history.
This is a different person, by the way. So other than those 3 DUIs, he really doesn't have any criminal history.
In this particular case, he cooperated with law enforcement. There's no allegation that he didn't. And he's a lifelong resident here. He owns a home. He's been employed at the same place for 30 years. So he's not a flight risk, and he's more than willing to comply with monitored sobriety as a condition of bond. And we would ask, and I note that he's a category 1 CPAT score. And so I would ask for the court to consider reducing this case or this bond to 5,000 surety with a cash option of 500.
Thank you. DA?
And Your Honor, I am seeing that a bond argument was made at the last court date. My notes are reflecting that the public defenders argued for a personal recognizance bond. With that said, the people would still be objecting to any decrease in bond. I recognize that Mr. Nye's 3 previous DUIs were happened a while ago. However, again, the conduct in this case is extremely concerning to the people and does pose community safety concerns. The defendant hit 3 vehicles. I believe they were unoccupied, but obviously things would have been different if those vehicles had been occupied.
That whole thing almost hurt my feelings. I love Thomas's English muffins a lot, but what if there is something better? But no, they can't be, because Thomas's are so good. I don't know, Twitchy. I don't know. I'm going to try them. I probably don't have them here, so I probably don't even have to worry about it.
It's only 2 vehicles.
The court denies your request to modify the bond in this case as well. It remains set at 20,000 cash or surety. The $2,000 cash option remains available to save you money, because I have confidence that you would show up in court. That's not my concern. Preliminary hearing, June 16, 1:30. See you then.
Thank you.
Yes, sir. Mr. Roberts.
Judge, that would be Robert Hernandez. And we would acknowledge receipt of that complaint and waive any reading thereof. And although it is a class 5, I see that he has his parole hold, so he's going to remain in custody, and we would ask that his case be set for preliminary hearing.
'25 CR 717.
Those are
Case
those
will
the
be
right
set for
ones?
preliminary hearing, June 16, 1:30 p.m. Division 7.
Your Honor, what if my parole hold is lifted before then?
If your parole hold is lifted, then you have to post the bond to get out. If you're asking, can you re-argue the bond if the parole is lifted? Your attorney is always welcome to bring that to the court's attention and let me know.
Parole June 4th.
That might have just changed, but we'll see about that. And if the parole hold is lifted, your attorney will let me know. Okay.
Thank you.
See you June 16. Mr. Loff, any other cases?
No, that's it. Thank you, Your Honor.
Let me take care of just a couple more out of county.
Could you?
Say it again. Okay. Yes, Jason Thompson?
Yes,
You
Your
there,
Honor.
sir? All right. Your attorney's ready again, 24 CR 32. Thank you for your patience.
Yes, Your Honor.
Ms. Land is here on your behalf for filing of charges. Ms. Land?
Your Honor, we are in receipt of the complaint. We'll waive any further advisement and ask.
We've been watching this guy who needs to shave for this whole stream. And I do this all the time. Like they'll have one guy on the stream the whole time, and he's not doing anything bad, but they'll be doing some weird stuff the whole time or going through other cases. And then you get to him and you hope that it's going to be good. That's how I'm feeling right now. I hope this is going to be good.
Preliminary hearing, a in-person writ to Douglas, although I anticipate he'll be here by then.
Finger up. That's a good sign.
Preliminary hearing set June 16, 9 a.m. Division 7, writ Douglas in person. Anything
Your
else?
Honor?
Yes.
I would just like to, for a second, if we could readdress my bond.
No, thank you. Thank you, sir.
And my apologies, Your Honor. When was that PH?
16th, 9 a.m.
Thank you.
Thank you, Deputy. Ms. Harold, you ready on your case?
So she had to log off.
Oh.
If I could just, I'm gonna have to now do a quick breakout with him and then we can handle it.
Okay. Can you do a breakout with Arapahoe in this lane? Done.
Thank you.
Sure. It's Adams County. Adams County here.
Yeah, and that's mine.
Oh, yours as well?
Yeah. What would you prefer first?
Why don't you take care of Arapahoe, Mr. Johnson? I'll take care of a couple more cases. So I think, Ms. Holland, if you're there, your attorney just stepped out to electronic courtroom. When she comes back, I'll get to your case. Anytime, Ms. Polkowski. You ready? Or maybe Mr. Emerson. I'm sorry, Mr. Emerson, do you have? Sorry, you have just one?
Two cases, Ms. Nestler and Ms. Hegden.
Let's take care of those then. Sorry, Ms. Polkowski.
No, no worries.
Ms. Hipton. Casey Nestler's case 25 CR 741. Ms. Nestler?
Yeah.
Where are you?
Good
afternoon.
Yeah, you just said no. No.
You threw me off. Oh, thank you. Ms. Nestler's on WebEx? Oh,
I
from
have
the,
her
I
on.
see,
Yeah,
from
she's
the
here.
module. I got you. Thanks for logging in. You guys confused me. Mr. Emerson's here on your behalf. Defendant's appearing in custody for filing. Mr. Emerson?
Judge, we acknowledge receipt of a complaint and waive further reading advisement. Need to set this for a PH, and I'd like to address bond as well.
Preliminary hearing, June 11, 9 a.m., Division 7. Does that work for your calendar?
Only if you tell me happy birthday on that date.
I will.
Okay, yes, it does.
I'll make a note. DA, you prepared to address bond?
Yes, Your
I
Honor.
bring the jam. She brings the butter.
Can you pull the case up?
Yes, Judge. So just very briefly, I think I'll highlight the negatives first. There's an FTA history. I've known Ms. Nestler, and there have been some issues coming to court in the past, but Judge, she has lifetime residence in the county, so she's got ties to the community. Her mom lives in and around the area, I think just outside of Boulder County, and she would, I presume, from speaking with her, would try to live there. We're not asking for a personal recognizance bond, just a cash option, Judge. And I would note that the case was filed as I believe, as an F6 trespass. So check the. Yes, the F6 trespass. So they're fairly mitigated charges for a felony.
DA?
Your Honor, I have no objection to a cash option, given that this was originally being investigated as a burglary and is now a F6 trespass.
Court modifies bond to include $150 cash option off the $1,500 secured bond. All the original same terms and conditions remain. June 11, 9 a.m., Division 7 preliminary hearing, as well as a birthday. We'll see you then, Ms. Nestler.
Thank you.
You're welcome. Ms. Hibden? Ms. Hibden, good afternoon. Let me get your mic on. Two cases, 25 CR 514 for filing of charges and a multiple trailing misdemeanors, 25M 416, 25M 414, 25M 154 Longmont. Mr. Emerson's here on all the cases. Mr. Emerson filing.
8 days ago, I stopped. I went on a strict diet 8 days ago. And it's all water right now. I am down like 7 pounds in 8 days. It's all water. I know that, but you guys are making me so hungry. And you're just saying English muffins, but I don't need an English muffin, but since I can't have an English muffin, now I want an English muffin only because I can't have it.
Same thing, Judge. We acknowledge complaint and information, waive further reading advisement, as set for a preliminary hearing, and I would again like to address
My
bond briefly.
ankles hurt so bad when I work at that.
Just gave you the
I
11th.
gotta
I
do
didn't
something.
know you were on this case. Do 11th on this one as well.
Sure.
June 11, 9 a.m. preliminary hearing in the CR case. Misdemeanor cases set at the same date and time. Trailing, I assume that's what you'd like.
Yes, please.
Bond on any case.
Yes, Judge, we're going to ask for a personal recognizance bond on this case. Ms. Hibben was seen this morning in Division 4. She has a felony case there. She does have a $10,000 bond in that case. But if you look at the totality of the cases, they are fairly mitigated. The cases that before the court, I believe, are an F5 on the criminal and the felony case.
Yes.
Then we have petty offenses and misdemeanors. So they look like just sort of basic thefts, shoplifting cases. Ms. Hibden also does have a long-standing ties to the area, not necessarily Boulder County, but to general Denver metro area. She would have a housing option to go live with parents as well. To the extent that she has substance issues, and I think there are some based on some of the cases we're seeing. She's motivated to get involved in some programs, Suboxone programs, as she has used them in the past, and she will continue to utilize those programs if available. And I believe they are available for her. So, Judge, we're just asking, as I indicated, for a personal license bond, or if the court can convert anything to a cash option.
Thank you. DA.
Your Honor, I would ask for bond to remain as set. Mr. Emerson and I, as he mentioned, did address bond this morning in her felony cases. And as I noted there, these are not the most aggravated cases that we see. However, it's just the number of FTAs that she has, the number of active warrants that she has. I do think she is a flight risk, and I do think that if she is given a PR bond, she will not reappear in court.
Request to modify bond in the case is denied. Bond remains set as is. June 11, 9 o'clock on all the cases. We'll see you then. Thank you.
Thank you, Judge.
Anything else, Mr. Emerson?
No, that's it. Thanks.
Which case?
If do you want to do Arapahoe?
Yes.
Okay.
Arapahoe 25 CR 714. Mr. Johnson, can you hear me?
Yes, Your Honor.
All right. Thank you for appearing and thank you for your patience this morning. The case comes on for a filing of charges. Ms. Land is here on your behalf. Did you get a copy of the complaint?
Yes, Judge, we are in receipt of the complaint, would waive any further reading and advisement, and would ask to set this case for a preliminary hearing. However, we're asking to set it out into a further cycle. Mr. Johnson is going to waive his right to have that hearing within 35 days.
Mr. Johnson, is that correct, sir?
Yes, Your Honor.
I'll accept that waiver of 35 days. I actually highlighted this because I thought you might be asking for that. DA, any objection to a July setting?
No, Your Honor, that actually works better with the people as well.
All right. I think we have the 14th. Can you confirm our dates?
Is
14, 17?
14th, 17th?
14 and 17.
Okay, well, that's not the date Ms. Harold sent, so it's the
I think if I ever get married again, I would get married August 31st because that's my other wedding anniversary. And then I don't have to remember a whole nother date.
And we'll move it if we need to.
Okay. Yes. Which one do you like, a Monday or Thursday?
Let's do Thursday.
DA, can you do the 17th?
That's July 17th.
Correct.
Yes, Your Honor, I can.
Preliminary hearing, July 17, 9 a.m., Division 7. Do you expect Mr. Johnson to stay in Arapahoe?
He should be coming here, but I just would ask for an in-person writ to issue if he's not coming here.
I'll make a note, Arapahoe writ, if he's not being transported.
Thank you.
Is there anything else to address?
Okay. Then no, Your Honor.
Nothing today. Okay. Thank you, Mr. Johnson. Thank you for your time and your patience again this morning. We'll see you July 17th, but your attorneys will come talk to you well before that, okay?
Okay. Thank you, Your Honor.
All right. Thank you, sir. Have a good day. Adams County, you ready on, Ms. Land, you ready on Ms. Holland?
Yes, Judge.
Okay. 24 CR 752 and 20 CR 1206 post-judgment. Lead case comes on for an advisement. Ms. Holland, let me just check on you. Can you hear me okay?
You're doing wonderful today, Your Honor.
Well, thank you for the feedback. I appreciate that. Nobody gives judges feedback, so at least not that kind. So I appreciate that. Thank you. Your case comes on for an advisement today. I have reviewed the file. I do find there's probable cause. I've issued a criminal protection order in your case that tells you you may have no contact with the alleged victim. Do you understand the no contact order?
Yes, I do, Your Honor.
All right, thank you. Relatedly, as a condition of the bond, I'm requiring that you relinquish, you give up any firearms or ammunition that you may have in your possession or control, and do so within 24 hours of bonding out. And relatedly, as a condition of the bond, ordering that you provide an affidavit, a signed document confirming that you've relinquished control or that you never had any firearms or ammunition to begin with. You have 7 days to provide that affidavit. Do you understand?
Yes, sir.
All right. Ma'am, regarding the bond.
Me and Micah are going to come and stream one day and we're just going to announce it. We got married. We don't live in the same state yet, but we just did a virtual ceremony and we got married last night.
Let me hear from the attorney, and then I'll set the bond. Ms. Land?
Your Honor, I would be asking the court to consider modifying the bond in the probation matter and then setting the bond in the newer case, well, I guess older, but newer case, to personal recognizance bonds. If the court is not willing to do so, I would be asking for low secured bonds with cash options. I guess I'll start by Ms. Holland and I discussed what had been going on with probation, as we obviously have that complaint in front of us.
Yes.
She lives in Adams County in Aurora. And I think that there was some type of confusion on when, how, and who was going to be transferring her probation to Adams County. I understand that took place a while ago, and she has not since figured it out. But what she tells me is that she was waiting to be contacted by Adams County, contacted them, and then never heard anything back. We did discuss if she is released on if she's able to post bond or released on a lower bond, that checking with probation within 24 hours in Boulder County would be one of the requirements, and she agreed that she would be able to do that. With regards to community ties, she does have a number of them. She lives with family and friends in Aurora. She has a huge family in the area. She told me she has 26 nieces and nephews, many of which she serves as a care provider for at various times after school, things like that. So she has a lot of family here. And when she's not doing that, she is doing some part-time labor with Labor Ready and Labor Works. I don't believe that she is a community safety risk. I understand that we have this case in front of us, but I will point out to the court that it is quite old and she has not yet, the newest case, she has not yet been seen by a court on it.
You think I edited this? Nope. This is the docket as it is.
To me, she hasn't had any contact with law enforcement. I do think that a lower secured bond or a PR bond would be appropriate with conditions of checking in with probation and then continued supervision by probation. Thank you.
Thank you. DA?
Your Honor, I would ask for bond to remain as set. I believe it's a $5,000 cash property surety bond in both cases.
Thank you. Bond remains set, $5,000 cash or surety in both cases. Conditions in the new case: no contact with the alleged victim, no contact with her residence. Report to your probation officer within 24 hours of bonding out. No alcohol, no non-prescribed drugs, no non-medical marijuana, no weapons. Comply with that firearm relinquishment and the affidavit. Filing of charges in the new case will be May 30, 1:30, back here at the Boulder County Jail. Adams WebEx
skip the ads.
will issue. Let me make it.
Please don't just skip the ads. If you can skip an ad, freaking skip it.
No. In the post-judgment case, conditions of the bond include report to probation within 24 hours and comply with that probation. That case will be set for a continued first appearance May 30, 1:30 here at the Boulder County Jail. And I specifically re-refer this case because of its age. Probation has closed out the case. Re-referring you to probation here in Boulder. And you can reinitiate that transfer if that is a reasonable thing for you
Cheat on
to
me,
do.
baby.
I'll see you in 2 days as a bottom line to see what charges, if any, the DA files in the new case. Thank you, ma'am. You can tell deputy we're done.
All right. I get zero content without Zoom court. The best thing that happened to me. All right, guys. Thank you so much for coming out. I got to end it now and hopping right over to OJ because I got a 2-hour OJ video with Furman that might be boring at first, but at the end, it gets really good. So I'm excited. And the court's open at 8. So I'm just barely going to make it now. Thank you so much for coming out. I really, really, really appreciate it. Behave today, guys, and have a great weekend. I'll see you soon. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out bright. Even when my world turns gray, with a giggle, she lights the way. Kathy's life.